In a personal injury case, the difference between getting millions of dollars for your client and losing the case and getting nothing can come down to your ability to effectively cross-examine the defendant's expert witnesses, specifically their doctors. Most of these cases come down to the credibility of the parties as well as the expert witnesses. In a lot of these cases, especially medical malpractice cases, it comes down to what we call a battle of the experts. This means the expert who explains their party's position better and is more credible and does a more effective job for their side, that side is going to win the case. Being able to properly and effectively cross-examine a medical expert will make or break your case. The reason most attorneys have a difficult time and find this a daunting task is because they simply do not have the medical knowledge to go toe-to-toe with the expert on the medicine in the courtroom. My name is Phil Rizzuto. I'm a trial attorney and have tried hundreds of cases throughout New York City in all 5 boroughs, Long Island, and Westchester. Most of the cases I've tried are personal injury cases, and what makes me unique is I've done it on both sides. I've defended these cases and I have represented plaintiffs and have gotten tremendous results for them. In this video, I'm going to explain to you how to effectively prepare for and cross-examine the defendant's doctor at trial. As the plaintiff, you are at a big advantage because the defendant's doctor, in most cases, only sees the plaintiff once. The examination lasts only a couple of minutes, and they are provided a limited amount of medical records to review in preparation for the examination. Additionally, in most situations, the examination of the plaintiff by the defendant's doctor is going to occur at least 1 year before the trial. This is tremendously important because in most situations, the defense attorneys or the insurance company who's insuring the defendant will not even bother to provide the defendant's doctor any updated or additional medical records. Moreover, in a lot of situations, they don't provide the doctors with all the medical records to begin with. One of the first things you should start doing to prepare for the cross-examination of the defendant's doctor is when you get the notice scheduling the examination of your client, your office should send somebody with the plaintiff to the exam to take notes. The notes should begin with walking in the door. What is the intake process? How many people are waiting in the waiting room? How long do you have to wait to see the doctor? What information are they requesting of your client? And by the way, don't make your client sign any forms. The representative from your office should take care of all of that, because anything the plaintiff signs is going to be used to cross-examine them at trial. So the person who is going to the exam should take any paperwork and fill it out on behalf of the client so that that cannot be used to cross-examine your client at the time of trial. Additional information is what information are they asking upon intake? Note specifically the time that you're waiting in the waiting room. A lot of times, these doctors are retired from private practice. They're only doing examinations for the insurance company, and the examining rooms are packed with people waiting to be examined by these insurance company doctors. And if you're there waiting for a long time and that's in a memo that you can read in preparation for the examination, that's going to be tremendously helpful. Additionally, what you should be taking note of, or what your representative should be taking note of, is at the time of the examination, what is taking place? What questions is the doctor asking? And what does the examination consist of and how long? This is one of the things you're going to use to cross-examine the doctor at the time of trial. First step in performing a killer examination is preparation, and more preparation. You need to review your file. You need to develop a theme for your case. You need to review all of the materials that not only was sent to the defendant's doctor, but that should have been sent to the defendant's doctor. So you need to know your file, you need to prepare a timeline of events and medical treatment, and you need to review the doctor's IME report, and you need to review that memo that your representative, whether it's a paralegal or an attorney or whoever it is you sent with the plaintiff to the IME, you need to review that as well and incorporate all of this information into a timeline. You need to research the doctor. You need to find out if this doctor has ever been sued. You need to know if he's ever had any disciplinary actions against him. You need to know if he or she has ever had their license suspended. And you need to find out from your colleagues and your friends any information that they have on this particular doctor. You should also look for any transcripts that may be available on cases this doctor has testified in. Just because you find information on the doctor does not necessarily mean it's going to help you. You don't have to use everything that you find, but you need to find as much as you can to weed out what's important, what is helpful, and what is consistent with the theme of your case and the theme of your cross-examination of that particular witness. Another thing you want to do is look for anything, any information in the doctor's report that he prepared for the defense attorneys and the insurance company that is helpful to you. Even if he reviewed records, if he reviewed an operative report, you can cross-examine him or her based upon the information in the operative report. Doctor, you'll agree that the person had surgery. You can find various information, MRI reports. If they were given an MRI report, you can question the doctor on the MRI report and the finding, especially if they are helpful to you. Look for information that is helpful to you and use that on your cross-examination of the defense expert. If the MRI reports are in evidence, then it's fair game to cross-examine the defendant's doctor on. If they are not in evidence, you need to be careful because now you are setting yourself up to look foolish, and it's not going to help you. In real trials, you're not going to have that aha moment, you're not going to have that smoking gun moment, and it's not going to be like A Few Good Men where you break down the witness and they start screaming that you can't handle the truth and you make them look bad. It's not going to be like that, especially with defense doctors. But a lot of them will try to go toe-to-toe with you and outsmart you, and you need to maintain control over them, which we'll talk about a little further on in the video. What you need to do is to prepare an effective outline for your cross-examination and look to attack the doctor in 6 ways. First is that they are hired by the defendants to perform these examinations, and get an idea of how much of their practice is devoted to doing this. Number 2, you want to establish what they were given, and you want to attack what they were not given, and that they were not given all the materials. And as the plaintiff's attorney, you have a big advantage because the examination is usually only one time. It takes place at least a year prior to the trial, and very, very rarely do the defense firms provide the doctors with any updated medical records prior to trial, which is also important for you as the plaintiff's attorney to make sure that your client goes for updated medical treatments after the examination and before trial, so that your witness can come in and testify regarding recent examinations, especially when they're going to testify regarding permanent injuries. Number 3, attack their practice. You want to find out how much they're getting paid to prepare the report, how much they're getting paid to appear in court to testify, how much of their revenue is generated from doing these defense exams, how many of the defense exams do they do a year or a month in relation to treating actual patients. And you also want to find out if they ever testify on behalf of plaintiffs. Also helpful, and it's very rare that a defense doctor will testify that he testifies on behalf of both plaintiffs and defendants. Usually they're strictly defendants. Number 4, the defense doctor is not there to treat the plaintiff. They're not there to help the plaintiff. They're not there to prescribe any medications or make any treatment recommendations. Their sole purpose is to review medical records and examine the plaintiff, to come into court to testify regarding this at trial. Number 5, how much time did the doctor actually spend examining the plaintiff? You can really attack the doctor here based upon how effective of an examination could he have done and how credible could their opinion have been based upon a limited examination of your client. Finally, number 6, you want to attack their report. And in order to do this, you need to have reviewed the report, and you need to go line by line by line in that report, and you need to find items that are consistent with your theme and attack it. It's very difficult for me to give you an exact script as to what to do, but you do need to go through the report
line by line and figure out what you were going to question the doctor about. Again, as you are doing this, and depending on how the doctor is responding to your questions, you may actually be able to turn the doctor around and make the doctor your friend, because these doctors have egos and they don't want to look stupid. So if there are a lot of materials that the doctor should have been given that he or she was not given, you may be able to convince the doctor, hey doctor, it's not your fault, right? They should have given you this information, and had they given you that information, maybe your opinion would have been different. You may get the doctor to say yes, because they do not want to look bad. In preparing for all of this, do not write out your cross-examination. It is okay to write out certain questions and have certain areas that you want to cover if you're starting out and you're not comfortable and you want to write out certain things. But it is much better to prepare an outline of what you want to accomplish, because if you write out your cross-examination, your intent, this is what you're going to do, you are not going to be effective, because you're going to miss out on a lot of stuff. So when the doctor is testifying on direct exam, you need to take notes. I do not recommend writing down what the doctor is testifying to on direct examination verbatim, because you will miss a lot of information that way, and you will not be able to adapt as you need to. One other important thing you need to do in writing out your outline, or if you're writing out your questions within the outline, is use language from the jury charge that the judge is going to give the jury at the end of the case. Now, this is particularly important when it comes to permanent injuries. In New York, in order to sue for a motor vehicle accident, you have to sustain a serious injury, which is defined as loss of a limb, significant disfigurement, loss of a fetus, fracture, permanent injury, significant limitation of use of a body function or system, or a medically determined injury that impairs your usual and customary daily activities for 90 out of 180 days immediately following the accident. So you want to use language from those jury charges, which is the law of the case, that the judge will read to the jury when possible. Make sure all your questions to the defense doctors are leading questions, meaning you have to suggest the answer to them in your question. Doctor, wouldn't you agree with me that you have not reviewed any additional records since you examined the plaintiff a year and a half ago? Don't ask open-ended questions, and give the doctor an opportunity to explain themselves. So now that you've reviewed all your materials, researched the doctor, you've reviewed the file, you're thoroughly prepared, you've reviewed their report, you've prepared your outline of your cross-examination of the defense doctor, you have your theme of the case, you have your theme of where you want to go with the cross-examination. Now you are ready for the big day, the trial. What is the first thing you do? You get up to the podium and you say, doctor, did you bring a file with you? And the doctor will say yes or no. And usually the doctor will have something. And you say, Judge, may I review the doctor's file? And depending on how thick it is, you will request a recess. Could be 5 minutes, could be 10 minutes, could be 15 minutes. But first thing you do, you ask the doctor for the file, and then you ask the judge for a recess so you can review the file. This is huge, and it could be a gold mine for you and could set the tone for your cross-examination. Why is it so important? If the file contains almost nothing, and believe it or not, some doctors will come to court with a file that contains almost nothing, and you could make a lot of headway with this thin file. How do you do that? Most times, this is not the doctor's first time testifying in court. So when the doctor has almost nothing in his files, and they almost never have the medical records that they've reviewed, you make a big deal of that. Doctor, this isn't your first time testifying in court, is it? And the doctor will say, no. And doctor, it's true, you've testified before. And in fact, you are aware that one of the first questions the attorneys will ask you is to review your file. Isn't that true? Again, that's a win-win situation, because most of the time they will say yes. And if they say no, they're not going to look particularly credible. Now, sometimes the files do contain more information. That is also helpful. That's why you want to take the time to review what is actually in the file, because if they have records, you can use the information that's in the medical records of your client that the doctor has reviewed to cross-examine the doctor on that information. So if there is a positive MRI report, that is helpful. Doctor, wouldn't you agree with me that the MRI report taken by this independent MRI facility reveals that the plaintiff has a herniated disc that is impinging on the spinal cord? What's the doctor going to say? No, I mean, the record is there. Look for any information that is helpful and use it to your advantage. The thing you don't want to do is mention the word insurance. You want to point out the fact that the doctor was hired by the defendants. Do not use the term insurance company because you will buy yourself a mistrial. Use the term defendants' representatives or defense attorneys, but stay away from using the term insurance or insurance companies. Once you go through the file, once you cross-examine the doctor on the file, continue your cross-examination in a consistent and methodical method. Do not let this doctor control you. Do not let them volunteer information that is not solicited. A lot of these doctors are professionals, and they want to do a good job because they want to keep getting work, and they hate plaintiffs, and they think all plaintiff cases are frauds, or all injuries are pre-existing and nothing is related to the accident, and they are arrogant, and they want to get their point across to the jury. And if you leave them an opening, they are going to ramble and go on and on and on and volunteer information that has nothing to do with the question that is asked. So you need to stop it. How do you do that? I will say, doctor, my name is Phil Rizzuto. I represent Mr. and I use the plaintiff's name. I'm going to ask you some questions regarding the materials reviewed and the examination that you conducted of my client to request at the outset that we have an understanding. If I ask a question that requires a yes or no response, that you only answer the question with a yes or no. If I ask you a question that requires an answer other than a yes or no response, please listen to the question and answer only the question that is asked. Can we have that agreement? And they always say yes. They never say no. Then you start off with some basic questions. Again, I usually start about the file. I've gone into some of the questions that I would ask the doctor about the file, and then you start getting into cross-examination that is consistent with the theme that you want to create. And when the doctor goes off on a tangent, you remind the doctor, I asked you this question. When we began the questioning, I had asked you whether or not we can agree that you would answer the question with a yes or no if it required only a yes or a no, or that you only answer the question that is asked. And then you say, do you recall that understanding? And the doctor will say yes. So as we proceed, can you please answer my questions either with a yes or no, if they require a yes or no response, or only answer the question without volunteering any information. And usually they will say yes. And if they say no, then you got a big problem and you need to get the judge involved. Usually they say yes, and then they do it again, and they do it again, and they do it again. And you got to keep reminding them. And if it gets to the point where it's obnoxious, then you get the judge involved. You say, Judge, can you please instruct this witness to only answer the question? And you can take it a step further, which is what I usually do. At some point, I will say, Doctor, I know you were here hired by the defense attorneys or the defense representatives to testify on their behalf, and you want to do a good job, but we had an understanding that you would only answer the question with a yes or a no if it required that response, or you would only answer the question that was asked. Can you proceed to do that? Otherwise, then I have to get the judge involved. And then usually the judge will yell at me and the judge will yell at the witness, but you need to maintain control of the witness. You need to let the jury know that the doctor is being a weasel and that he or she is hired by the defendants and they're not really doing the right thing by volunteering all of this information. And the juries don't like it. The juries do not like when the doctors are weasels and when they do that. So the key factor for you is to maintain control of the witness, and sometimes it requires getting a little down and dirty and confronting the doctor head on with what they are doing. So the main points for you to remember are you have to know your file. You have to have a theme for your case. You have to research the expert, and you have to prepare methodically for your cross-examination of the defendant's witness. Do not go for a kill. Your questions need to be consistent with your theme. They need to be methodical, and you need to establish your points. Do not swing for the fences and think you are going to destroy this expert and make them look foolish and you're going to win the case. You need to score points. You need to have your theme. You need to be consistent with your theme, and you need to establish what you set out to do. Do not let the doctor get away with volunteering information. You control the witness. The more you do this, the better you will get at it. Just do it and do it and do it, and you will get progressively better. If you have any questions, please leave them in the comments or feel free to send me an email at PRizzuto@rizzutolaw.com, or feel free to call me at 1-855-Rizzuto or 516-622-0606. If you found this information helpful, please like the video, subscribe to the channel for more useful tips, and I will see you there.